Thank you very much, Prof. Shad. Thank you very much, Andrew, as well. Again, as I mentioned last week, I would like to call for attendees to give a round of applause for excellent speech and inputs which is shared. Um, Before opening up to the attendees for questions, while at the same time, I would like to invite all attendees to share any questions that we would like to have at the Q&A section in on the Zoom window at the bottom of the window. I think it's quite standard with everyone. Um, but one thing I would like to point out, which is being mentioned, I think both by Andrew and also Prof. Shad, particularly now moving towards the, I would say, uh, after going through, after we as a society have gone through several weeks of the movement control, we could sense that the authorities are taking actions to start to decrease the amount of restriction. And as Andrew pointed out earlier about the elements of the essential services are started to being opened up, um, of course, initially with food products, later to certain services. But when it comes to the needs of religious communities to either hold ceremonies, which could be in a different range of scales, meaning that understanding even religious ceremonies have various scales. They could be some with lot of gatherings of hundreds or to hundreds of people. But giving an example, uh, um, some prayer sessions maybe can just be conducted with just maybe 10 to 20 people, meaning that a closer amount. From what I am aware, based on getting through the updates, I have yet to notice that the religious authorities in Malaysia, at least, of giving up new suggestions of coming up with recommendations, which is may not be will not be an overall rule about the restrictions, but perhaps suggesting with um, restriction of religious activities, maybe when it comes to limiting numbers or providing other options rather than a full restrictions. Maybe you can, Prof. Shad or Andrew, could comments or on that.
Okay, thank you for that question. Well, I think there are religious leaders that are creating temporary innovations in the way that religious services are being conducted in order that they can, in a sense, respond to the limitations that are currently in place. So, from a Christian perspective, for example, we are having services online, for one thing. We are having small group meetings online for those churches that work that way as well. And also then, in terms of the perhaps more ceremonial services that some more traditional churches perform, they have also tried to find some ways to not perhaps replicate that, because certain parts of that service cannot be replicated virtually, but at least to create some sort of circumstance or situation where you can be a part of that service as much as possible. So it's been tailored, it's been adapted to try and accommodate the needs of the congregation, the needs of the believers, but also the rules of the church or the rules of the religion in relation to those kinds of services. So I think, so people are being creative. Necessity is the mother, in this case, perhaps not of invention, but of innovation. But they are limited by their own doctrinal prerequisites which still can't be changed, notwithstanding the situation that we're in.
And to add, Prof. Shad, I
Yeah.
like to Prof. Shad's comments about, or mainly statements about discussion before decision. It's a very
Yes, yes.
amazing phrase, which
Yeah,
I think
yeah.
should be important part. Maybe you can add more.
Yeah, actually, Asan, I'm speaking off the cuff as to what needs to be done to provide the essential service that religion does supply in society. Andrew did point out correctly that digital online services are being provided. I read somewhere about drive-in services in some churches, especially as to the confessional. People can drive in. I would think TV can play a role. Up to now in this country, um, um, because of the interpretation of some people, um, um, the national media, TV, the radio, does not really broadcast the religious services of other religions. I think in this crisis, emergency situation, I think media can play a role here. I will give you my example. My family and I often watch the Hajj on TV. We find it very, very significant, even though we may not be there for that year, though we have been on other years. We sit down and watch, and actually it's very meaningful, even though it's all far away, it's very meaningful. So the media can play a role, and I would be prepared to recommend that during this crisis, we should be large-hearted. The Muslims must be large-hearted. I think the media should be allowed to televise essential religious services and occasions, so that the faithful who are unable to go physically because of the movement restriction order can at least observe it on their TV screens. But I'm sure many more suggestions are possible. May I just repeat what you said? We need discussion. We put heads together, I'm sure we'll come out with solutions. But what is quite clear from the view of Andrew as well as myself is that religion is an essential service and it should not be ignored. And I think we need to do more to make religion accessible. Um, Not just what people believe in their heart, but I think manifestations, if I may use Andrew's words. Thank you.
Thank you very much, Prof. Shad. There are several questions at the Q&A part.
Okay, fine.
Most of them relates to some points related to the law. Though there is one interesting comment question raised by Tan Chi Kyong and the chat section, which I think may not be something that we have the time to discuss in detail, but maybe some interesting part if speaker would like to just touch on. So Tan Chi Kyong raised the question, I'm curious to know the history of congregational prayer vis-a-vis the solitary prayer with the Jewish, Christian and Islamic tradition. Is there anything that we can learn from that part of history of humanity in terms of safeguarding freedom of religion? Definitely, it's a very broad and comprehensive question being posed on why is it the importance of congregational prayers in itself, and perhaps how does that relate to the importance of freedom of religion? Perhaps Andrew and Shad would like to, Prof. Shad would like to add any points?
No, I won't be able to. Actually, I know that worshipping together it gives me a lot of satisfaction when I go to the mosque. But the history of congregational prayer, now I won't be able to answer much on that. To me, worshipping as a group in community, as well as worshipping in your own solitude. I think both are very important, and I would not want to take a stand on what is more important. I'll let Andrew talk about this history. In Islam, certainly congregational prayer is very important, especially when it comes to Friday prayers, and of course the Hajj is all something that we do together. Even in your home, you try your best to get someone else to pray with you. Yes, it's important, but the history part, I won't be able to. Tan Chi Kong, I'm sorry, I won't be able to elaborate on that. Thank you.
I'm not a religious historian, but from my reading, from my own faith background and experience, I mean, faith is never just something of personal piety. It is also a public affirmation. So the idea that it is something that is just private and personal to you is not something that I think the major religions suggest. I mean, there are times of quiet reflection, personal meditation, but the idea that one can congregate together with other fellow believers and to affirm each other and to affirm the body, as it were, the body of believers is, I think, something that is as old as religion itself. And in terms of the question of prayer, I suppose, you know, I mean, for a long time, a lot of people of faith did not know how to read or write. So in some ways, they were always led by someone. So whether it was a lay person leading that group or whether it was some sort of religious official, I mean, that has evolved through time. But the idea that people come together in mutual support and affirmation to join together in prayer and so that kind of congregational prayer, I think is something that is a foundational teaching of most religions, because it's not just about you. It's not just about vertical relationship. I mean, whether it's in Islam or in Christianity, you have the similar idea of, well, there is the vertical relationship, the ibadah or whatever it is. But then there's also the horizontal relationship, the muamalat. And so religion is a combination of both. And so the idea of the congregation is one that is important, at least both in Islam and in Christianity.
Thank you.
Yes, indeed. I would support that fully, that there is ibadah and there is muamala, that your social relationships with others is a very important part of religion. In fact, as I was quoting from Khalil Gibran and before that, the Holy Quran, I think your whole life, your interaction with your fellow human beings is part of your religion. Yes, I fully endorse Andrew's comments that religion is not only about entering the recesses of your soul, yes, but also affirmation with others, indeed.
Prof. Shad and Andrew, especially on the point, why is it the topic of freedom of religion a difficult, quite a challenging topic that as we are dealing it now, especially on elaborating based on the points elaborated by Andrew about the more community and the social nature of religious activity, which we are having now. Okay, I will straight away look into the questions which are addressed by several of the attendees. I'll start with the questions by Adriana. Okay, this one, Adriana asked, must be prescribed by law the limitations to the freedom of religion. Must such prescribed law be enacted through parliamentary process, or can it be passed unilaterally by a ruling government? So such prescription of law in limiting the rights to freedom of religion, can it be enacted directly, unilaterally by a ruling government, or must it go through a parliament first at the current situation?
I think that's a very good fundamental question. And I will just say this, that the basic concept of the rule of law is that it should be a government of laws and not of arbitrary power. The government's power must be derived from the law. Rights are inherent. It is power that needs legal justification. All power requires legal justification. So in answer to you, Adriana, the limitations imposed on the citizen must be derived from the law. Now, what do we mean by law? By law, we mean the Constitution. We mean acts of parliament. We mean subsidiary legislation. And of course, there are many other types of laws. There is common law, judge-made law, but it must be derived from the law. It cannot simply be something the minister says, okay, I think this is necessary, I'm going to impose this. It cannot be based simply on necessity or on reasonableness or on what the minister feels is the need. It has to be derived from the law. I think that's the distinction between rule of law and rule by law. That's very, very significant in a legal system, that the government doesn't have inherent powers. There used to be a lot of inherent power. That area is decreasing, and the more democratic a society is, the more the idea must be accepted. The power must be derived from the law, must be anchored in the law. I'm just giving a silly example. So I'm not wearing a tie. Let us say you are a very senior minister. You say, hey, you, why aren't you wearing a tie? I'm entitled to ask you, hey, you, which law says I must wear a tie? So you have to find the law which requires me to wear a tie. I don't have to find a law which permits me not to wear a tie. You find the law which requires me to wear a tie. In other words, power is not inherent. Rights are inherent. Power must be derived from the law.
Thank you, Prof. Shad. There's also an additional question by Adriana. In such situation when there is a prescribed law, is whether the law is derived from existing law and issued in the form of a directive, or can it be bypassed parliamentary discussion? Or perhaps Andrew would like to comment on that as well.
Yeah, so building on what Prof. Shad has said, I would go one step further and to say that even if a law is passed and it conforms to the form of the passage of law, I think when you look at the rule of law, and Prof. Shad spoke about this very eloquently last week, you have to satisfy the criteria of the rule of law. In other words, there has to be consultation. There has to be, in a sense, the fact that it is something that doesn't transgress accepted legal norms and standards. So you can have the power to pass a law, and then the minister can say, well, okay, I've decreed this under the statutory powers given to me. But if that law is manifestly unjust, then it may be formally valid, but substantively not so. So I think Ariana's question goes to that. It's not just about whether it's complied in a very mechanical fashion with the various steps and requirements of the making of law, but whether substantively it has complied with the international understanding of what the rule of law really means.
Yes, I think I just add to that. So Adriana is clearly on point there, that first of all, the law must be derived not from personal power or political power. You don't have power just because you're holding an office. It must be derived from the law. Secondly, though it is derived from an act of parliament or a piece of subsidiary legislation, these must be in accordance with the Constitution. And our courts have beautifully said that to be in accordance with the Constitution, there must be proportionality in the law. In some countries, they go one step further. The law must also be in accordance with international norms. Malaysia is still developing in that area, but in answer to your question, Adriana, it cannot simply be something the minister feels is necessary. It has to be anchored in the law. And the word law doesn't simply mean any law whatsoever. It means not just legality, it means just legality, a law that conforms with certain standards.
Thank you, Prof. Shad and Andrew, on your response. I'm going to address the next question by Dr. Imran Ali Sandanau. Interesting question, quite straightforward. If those religious leaders who challenge the law or government in the situation of COVID-19, okay, I'm putting an assumption it relates to some religious activity matters, can government take action against them?
Well, just because someone challenges in a court of law, if that's not a ground for taking action, the action the government should take is to defend itself in a court of law. Earlier, Andrew correctly pointed out the issue of essential services. I take note that in the 1980 attack, Andrew, perhaps you could correct me on this. In the 1980 attack, the courts, the judiciary, the legal profession are not essential services. And in my view, that's quite unconstitutional. I think the courts are a separate, independent, essential pillar of our constitutional system. So judicial services are, in my view, clearly essential services. So in answer to Dr. Imran, well, the government's action should be to defend itself by pointing out the authority of the law under which it acted and to prove the constitutionality of the law and defend itself. But to punish people simply because they challenge the government, that would be most undemocratic and, in my view, even unconstitutional. My humble opinion is that access to the courts, being able to go to the courts, is part of personal liberty. Personal liberty is not, personal liberty in Article 5 is not simply freedom from arrest. Personal liberty is also to be able to go to the courts to seek enforcement of your rights. And also, being able to go to the courts is part of our right to equality before the law and equal protection of the law. So the words life, liberty, equality must be interpreted prismatically, broadly, to encompass many of these other freedoms. I think the right to go to the courts, to knock on the doors of justice and say, I have a complaint, I think that is an essential part of a constitutional legal system.
If I may just chip in a little bit, I mean, I think if one were to take a perhaps a very purist idea of separation of powers, then the court has an inherent power and should not be restricted in its operation by the executive through the passage of laws or the issuing of regulations that try to say that it is or it isn't an essential service. The 1988 Act itself, the body of the Act, doesn't speak about essential services. It's the regulations that introduce the idea of regulation, of essential services, and then it defines what those essential services are. So one can take possibly two views. One is that if the judiciary and the legal profession and the administration of justice is not mentioned as an essential service, does that mean that it's not an essential service? Or do you take perhaps a more higher level argument that no law can restrict the administration of justice, and therefore there is no need to name the courts and the legal profession and the administration of justice as an essential service, because by definition it has to be. And any idea that it is not an essential service is absurd.
I was thinking in terms of, let us say, Article 5, Clause 2, the writ of habeas corpus. Let us say someone is arrested under the movement control order, and let us say he is put in a remand center, or he's prosecuted, convicted, and he wants to apply for the writ of habeas corpus. I think he has a right under the Constitution to do so. Whether the courts are an essential service under the regulations, as you correctly point out, to me, I think whether the law allows the courts to operate or not, I think the judges have a duty to hear his petition for habeas corpus under Article 5, Clause 2.
Indeed, and I think the judiciary has issued circulars to say that on urgent matters, these are the people that you can go to, these are the courts that, and these are the judges that will hear these urgent matters. So from a practical perspective, the courts have basically indicating that they are open for business, and regardless whether they have been mentioned as essential services or not.
Yeah, blessed be the courts. That's wonderful.
Okay. I would like to add on another question by Dr. Imran Ali Sandano in regards to some SOPs on religious practices. Yeah, Dr. Imran's question. Some states have developed SOPs for religious practices like Indonesia and Pakistan. In Pakistan, some were arrested who broke the SOP but later released due to pressure by religious leaders. Is it practical or is it applicable in such situation? Prof. Shad or Andrew, respond.
I'm sure SOPs would be fine, but of course, I don't know what the substance of these standard operating. I presume you mean standard operating procedures. Yes, it'll be a good idea to draft some. As we said earlier, I think we need to put our heads together. This problem is much too huge. The need for balancing is equally very great, and this cannot be decided simply from a top-down view. I think we have to rely on the genius of the people, of the official as well as unofficial religious organizations, and I think they must supply their wisdom to the government to be able to work out SOPs as to how we can keep the flame of human rights alive, at the same time safeguard people from this very infectious disease.
I think I would just make two comments. The first is that SOPs are, by the nature, they are practical, administrative, well, for want of a better word, guidelines, instructions, decided or created by someone in some position of authority. And the question then is whether or not, in coming up with those SOPs, what involvement has there been with other stakeholders? What consultation has been done? I mean, if you want to talk about human rights-based approach, then you should be talking about, well, we can make these rules or guidelines or procedures once they have achieved a degree of consensus amongst the stakeholders, so that we can all agree. Because these guidelines or SOPs may not necessarily have the force of law. So in order to achieve maximum buy-in by all who are affected by it or could be affected by it, then the most ideal way to create these SOPs is by consultation. The second point I'll make is I think something that Prof. Shad has spoken about both last week and today, and that is, we live in an environment where orders from above are hardly challenged. And so if somebody sends out a letter and says, "Ini arahan dari atas," right? The underlings don't question it. And then when they come to the service face with someone, a member of the public, and says, "I want to do this." "No, you can't." "Why can't you?" "Well, it's against the guidelines." Who created the guidelines? "So these guidelines came from, my bosses or the head of department, or whatever." But under what under what authority, under what power were those guidelines put into effect. And for a long time in Malaysia, we've had a culture of us being very obedient to guidelines. So much so that the government doesn't really need to pass laws, because they say, we don't need to pass laws because people will respect the guidelines, or there will be administrative ways in which we can enforce the compliance with these guidelines. And so we have, we are the product of our upbringing. We have become very obedient citizens in terms of complying with guidelines. And so I think we need to be a little cautious about the source of these guidelines.
Hassan, just wanted to clarify these SOPs, something similar to what actually Adriana was asking earlier, orders, instructions, there could be some similarity. The SOPs could possibly be derived from a law, in which case they would have the status of a subsidiary legislation by whatever name called, or they could be purely administrative guidelines. Now, if they are pure administrative guidelines, then they are not law, and you cannot prosecute someone for their violation. I know that in actual practice, we tend to regard any SOP as having the force of law, and non-compliance would mean that we would get into trouble. But I wish to clarify that actually SOPs, unless they are derived from a superior norm of law, either the subsidiary legislation or the Act of Parliament or the Constitution, such an SOP has no legal effect. But of course, even though it has no legal effect, there is no bar to obeying it. But if one does not obey, then I don't think there can be a prosecution in a court of law, because it's not law. Courts are courts of law. They are not courts to enforce SOPs. However, what can happen is within the office itself, or within the club, or within the organization, administrative action could be taken. Suppose, as I said earlier, I didn't wear a tie. Well, if that is the internal guideline and I didn't follow the uniform requirement, then internal tata tertib, discipline could be taken, but I cannot be taken to court for not wearing a tie unless the law requires that. And actually, if someone were to take me to court, I would plead, I would call up Andrew and say, Andrew, please represent me in a court. Article 10, Clause 1A, freedom of speech and expression. Whether I wear a tie or not is part of my freedom of expression.
Thank you, Prof. Shad. I would like to point to the question and quite a long comment by Satish Ramachandran. So Satish Ramachandran started with providing some views on belief in religion, which is of a personal and private nature between the person and God. I think Andrew commented on this part earlier excellently. So I will move straight to the main part of the questions, which relates to religious organizations and the registration at or with the Registrar of Societies. So the question goes that many religious organizations are compelled to register as societies. So the question mainly addresses to Prof. Shad. What is your view on this freedom of religion and freedom of religious organizations to organize themselves? Why should we have to register as a society under the Societies Act? I'm sure this one must be related to the rights of religious freedom as well. Prof. Shad, if you would like to comment.
Actually, it's a very good question indeed. Not just religious organizations. Actually, commercial organizations have their own laws. They have to register. Trade unions have to register. You see, once you want to organize yourself into a group and carry on activities as a group, which is certainly protected by Article 10 Clause 1C, freedom of speech, assembly, association, freedom of association. Yeah, I think that's a constitutional right. But to regulate it by requiring some kind of registration, I don't think that that's a bad idea, because, once people organize themselves like that, there is often acquiring of property, there is raising of funds, um, and in some of these issues, there is a great deal of dispute that occurs. I do not wish to say this as an insult to any religion, but around the world, there are religious groups, all religious groups, that will find the smallest opportunity to set up a shrine or a temple or a place of worship, and then people will gather around it. It will become actually a location for assembly. Now, we had, I was involved once in a study with the Just organization on this issue of places of worship. There are scores of places of worship which are not registered, which basically involve an encroachment on a public piece of land, but setting up of a religious symbol and therefore attracting loyalty. So I will be very happy to be corrected on this, but I think requiring people to register places of worship or places of business or trade unions is not a bad idea. But what is important is this: there should be no unequal treatment. Article 8, equality must apply. There should be no arbitrary exercise of power. There should be no unreasonable restrictions. So I think that's very important, that though there should be regulation, it should be in accordance with the law. Thank you.
Thank you, Prof. Shad. Andrew, is there any point to add?
I mean, I would agree, Prof. Shad, that I think organizations should be registered, but I don't agree that it should only be registered under the Registry of Societies. I think
No, I didn't mean that at all. I didn't mean that. Okay.
I'm just taking that one bit which I agree with you. I'm just adding the fact that I don't,
Okay.
there should be no compulsion in terms of which form that organization should take. So, for example, we have had in the Companies Act way back since 1948 in Malaya, then Malaysia in 65, this concept of a company limited by guarantee. And in fact, in the new Companies Act of 2016, the idea is promoted even more, that a company limited by guarantee is probably a good vehicle for a not-for-profit organization. And a lot of the religious bodies or religiously affiliated organizations are generally run on a not-for-profit basis. And so the idea is that you have some sort of permanence of existence, a separate legal personality in legal jargon, so that the arduous practicalities of changing the owners of the organization are avoided. Because under the Societies Act, the society doesn't have a separate legal personality. It's still in the name of the office bearers. And so when the office bearers change, you have to keep changing the registration. Whereas with a company limited by guarantee, you have a separate legal personality. So the directors may change, but the company lives on, as it were. So there's a great degree to be said for a more certain existence. And after all, as I said in part of my presentation, Article 11.3 gives to basically religious organizations the right to manage their own religious affairs. And I would understand managing one's religious affairs to include the kind of vehicle that they would want to choose in order to establish themselves. And so the law should not say you can only be this and no other.
Now, I agree with that totally. Actually, I didn't mean to say they must all be registered under the Registrar of Societies Act. In fact, Andrew, time doesn't permit. There are at least about 15 or so statutes in this country, statutes which actually through legislative instrument recognize various religious organizations. So I'm totally on all fours with you. The vehicle for organization should be left to the religious organization itself. In fact, not just religious organization, there are, for example, women's groups that don't want to register under the Registrar of Societies Act. They register as a company. Why not? The important thing is that there should be some openness about it. I'm sad to say this, but religion can become a good business. And sadly, it is abused. We have had quarrels between people, various groups, religious groups. So I think there should be some openness about people who organize, who raise funds, especially those who raise funds. Some registration is necessary, but in what form? I totally agree with you. The vehicle should be left to the organization itself.
Thank you, Prof. Shad and Andrew, on responding to that question on registrations of society. It's quite an interesting question because new organizations related to religion would surface from time to time. A lot of new organizations will surface, whether at the community level or whether or at the more society level. And in fact, a lot of religious organizations tend to also now become like a hybrid model with a more business entity as well. It shows how things have developed and evolved over time. And the need for some amounts of registrations, monitoring also relates to the importance of the topic that we are discussing about religious freedom. Okay, just before we end, there's one final question that I would like to put in, though this question by Izzat Razi. I think it's not directly a question relates to the situation of COVID-19, but rather discusses about religious freedom in rather general. Responding to Prof. Shad's presentation earlier also relates to a universality of teachings of religion. So the question by Izzat, how do we frame or make conducive to students of scholars from another religion who is studying another religion while remaining true to his original religion, I would say.
I'm sorry, I didn't get that. I didn't get that last part. People study other religions. So what's the problem?
Yeah. How do you frame or make conducive to students or scholars from another religions to study another religion, from one religion to study another religion while remaining true to his original religion? Were there any challenges on that one?
Yeah. Well, it's a very, very large and very wise question, something I'm not really qualified to handle, but I'm just speaking from my own personal experience. First of all, if we were to study other religions, what we will find is many commonalities. And that would be beautiful because in many, many respects, there are religions that share common ideals, common aims, and that would actually help us to become closer to each other. At the same time, study of other religions, comparative religions, would also clearly outline the major differences. These differences, in my personal view, should not lead us to look down on another religion, but to see that that religion's approach is different from ours. So may I just give one example? As a Muslim, I am not allowed to give away my property except to the extent of the bequeathable 1/3. 2/3 must go by way of inheritance. Now, someone may say, hey, that's a violation of your freedom. It's your property. You should be allowed to give it to whom you like. But you see, I would then respectfully answer and say, well, yes, in a way, it's a restriction on my right. But because the overriding principle is that I cannot be allowed to cut off my relatives, my wife and my children. So there is the importance of the family, the duty to take care of those who are your kith and kin, that is recognized. So if I mention that to my colleague who may belong to a different faith, I would think that he should accept it as a reasonable difference. We don't have to say, so your religion or your faith is lesser than mine. I think we can see that there is a point in this rule. Of course, truth is multiple. So I think that's the point I want to make. First of all, we'll discover commonalities. Secondly, we'll discover that good can be achieved, virtue can be achieved in many, many ways. And I think that would make us more tolerant of others. At least that's what happened in my life. I went to the USA for a degree in, basic degree in government. I was required to study the humanities. The first semester, I had to study the Holy Bible, King James Version, the Holy Quran. In an American university, I had to study the Holy Quran, Plato's Republic, and there were a few others, Upanishads. Five books were prescribed. Actually, at the end of reading these 5, I developed a lot of respect for the other faiths. And I have to credit this to my professor. His name was Professor McAllister. This is 40 years ago. He allowed me in the humanities class to read out the Holy Quran by way of recitation. And I think we all learn from each other. So coming back to your question, Razi, I think the idea that just because you acquaint yourself with other religions will weaken your faith, I have very strong objection to that belief. Very strong objection. I think learning about other people's faith would in many respects strengthen our own. We will see the differences, and in many respects we'll also see the commonalities. And I see there is nothing wrong with that. There are many, many approaches to achieving the truth, many, many approaches to being good citizens, good members of the human race. Last time I did mention this point, that many of us, or all of us, are human beings, but we do not necessarily understand that being a human being requires us to have humanity. Many of us are lacking that. So I think studying other religions is a very good thing to do.
Thank you, Prof. Shad. While you're giving comment, suddenly there's like another question pointing was shared by one of the attendees. So I'll read through this final 2 questions that later maybe Prof. Shad can just give comments or answer, and also Andrew as well as part of your final concluding remarks. Yeah. The first one is by Dr. Imran Ali Sandono, specifically addressing this question to Prof. Shad Salim Faruqi, saying that Prof. Shad missed to quote China in terms of minority rights. Please comment, please. I'm not too sure exactly on which part is it that Dr. Imran Ali Sandono is pointing out, perhaps referring to your earlier talk earlier, just in case if you have something to add. On the second question by Lo Pai Ling, this one relates to the earlier discussion on registration of religion. So the question goes, some religious organizations are functioning under the Article 11 of the Federal Constitution of Malaysia with no requirement of registration with any authority or party concerned. The only requirement is a letter from the recognized federation or umbrella body of the respective religions. What is the comments of the speakers? So I will straight away pass to Prof. Shad and later to Andrew to respond and also to share your final remarks on the topic.
Yeah, Imran, on the issue of leaving out China, yes, I think that's something unintentionally, I didn't mean to. I'm not in any way implying that China's record of human rights in terms of religious minorities is good. Not at all. I think China has to buck up there if it wants to become it is already is, if it wants, besides being powerful, if it also wants to gain respect, it must improve its human rights record in this area indeed. I was talking more in terms of the COVID-19 issue. And yes, but I acknowledge I should have mentioned China also. As to this next question, perhaps I'm not the best person to answer here. Maybe you could help me here a little bit, Andrew, about some organizations registering only with their parent body. But is the parent body registered? That I do not know. Personally, I like the word that you use, any vehicle which they use for their registration should be up to their choice. All that I want is there should be some openness about it. Because I know for a fact that disputes occur between rival organizations. I know for a fact that there are disputes about property, there are issues of raising funds. So I think there should be openness. But which vehicle? Maybe, Andrew, you could help me on this. The question was that some organizations don't really register under any law. They merely register with their parent organization.
Yes, sure. So, but before I answer that question, let me just comment a little bit about the China question. More to say that, you know, what we can see from other countries is the danger of giving to a central authority far too much power when it comes to emergencies, and I suppose in China's case, not even in emergencies, where there is an ability to restrict the freedom of religion of a particular religion. So China being one in their treatment of the Uyghurs, but also you know, if you look at Hungary, where, you know, they have given to their president near absolute powers in this time of COVID-19 emergency, to the extent that he can basically ignore or sidestep parliament in making presidential decrees. So I think there's always a danger when you concentrate too much power in the hands of a single individual or a single body, because then there is the temptation to transgress on the human rights of some of the people within your control. And usually this will end up being minorities, minority groups, minority communities, and in the case of China, minority religions. So I think that's a cautionary note that we need to bear in mind. In terms of Sister Lo Pai Ling's question, hello Pai Ling, you know, I mean, if I can draw an analogy, you know, using the vehicle idea again, you know, some people have cars, and if you have a car, you need a road tax, you need a driving license, right? Some people have bicycles, for which you don't need road tax, you don't need a driving permit. So some people may feel that there is no requirement on their part, there's no need on their part for the activities that they are undertaking to come together and formalize their association or relationship by establishing a particular organization or establishment, which then requires you to be registered. Of course, there are certain practical complications to it, or practical consequences to that. So, for example, if you were to hold funds and you want to open a bank account, then the bank may say, "Well, we need, a copy of your certificate of registration of some sort." And if you don't have one, you might not be able to open a bank account. So then you may end up having to open a bank account in the name of an individual, and then he or she holds it on trust for everyone else. And then, as Prof. Shad has said, there could be, unfortunately, it could be a dispute in the future, especially if that person doesn't tell his family that this money is actually not mine, it belongs to this organization. And if that person were to pass on, then they'll say, well, oh, look, so-and-so has money in this account, it must go to us, and then there'll be a dispute as to who that money belongs to. All those kinds of issues which you, I think, want to try to avoid. And of course, unfortunately, where the Registrar of Societies or the Societies Act is concerned, there's actually an offense of operating without registering. So, if you look carefully, if you basically smell like an association, you look like an association, then unless you register, you are actually breaking the law. So I think you also have to contend with that kind of legislation as well. So it actually criminalizes you for not registering. So you may want to take a closer look at the provisions of that relevant section in the Societies Act to see whether or not you could fall foul of it. And one last thing when it comes to ROS, it's something I wanted to say, but didn't have a chance to say it earlier. Quite early on, when the MCO was being announced, the Registrar of Societies basically issued an order compelling all societies to cease any activities during the period of MCO, right? So this is then the issue. If you are a society that's registered under the Societies Act and come within the purview of the Registrar of Societies, you then have to comply with the ruling, the order coming from the ROS. And so if you are a religious-based society, does this then mean that you cannot have any religious activities, whether online, offline, because you are bound to obey, to comply with the directive that's come from the ROS? And so I think that this is, we've not really gone into that, but this is certainly one of those other issues about freedom of religion in this time, when people make these kinds of cross-cutting orders, umbrella orders to prohibit you from doing X, Y, or Z, then you may inadvertently end up violating someone's rights to freedom of religion because it's a religious-based society.
Very much, Andrew. Thank you very much, Prof. Shad, as well, for your sharings and inputs. I realized we started the whole discussion focusing a lot on the situations and concerns related to the MCO and its relations to the situation of religious freedoms due to the virus conflict. But later, as our conversation continued, we also addressed a lot of other important topics, including registration of religious organizations, and also practices and a lot of interesting examples Prof. Shad mentioning about when it comes to wearing a tie, and also Andrew mentioned about driving cars and as well. This shows how the discussion about religious freedom, how does it relates to the law and our situation in our current time, modern nation state, in one way to see it, relates to things could be quite complicated from time to time, and the discussion must always continue. I will just to ending with the final, my favorite quote or phrase of today, coming from Prof. Shad surely. whatever situation is first start with discussions before decision. Hopefully that will not only remain relevant to our situation of the movement control situation, but it can be as quite important principle in this, looking into a lot of other issues as well. So I would like to once again thank Prof. Shad Salim Faruqi for again being part of our conversation.
Thank
And
you very much.
also Andrew, who for your sharing, responding to questions. And I would like to also thank all the attendees, participants who were posing questions and listening to the talk that we had today. Just before we end, I would just to like to point out that we are currently also planning another session of talk um, next Saturday with Dr. Chandra Muzaffar and Dr. Emir Hazi Kadunich, the Bosnian ambassador, um, on a topic about post-COVID-19. Is there going to be a new world order? Understanding the whole situation of COVID-19 threat globally now, it also shows some kind of interesting developments on international relations and international politics as well. So I shall end our discussion here, and I would like to wish everyone well. For Muslims of fasting, I would like to wish a good breaking of fast a bit later today. And to Prof. Shad, thanks again. To the Andrew, thanks again. And thank you to everyone. See you all again. Assalamu alaikum and have a good time.
Alaikum
Thank you,
salam. And
Ehsan.
thank you to all your listeners.
Yeah, and blessed Ramadan to all our Muslim listeners. Thank you.
Thank you so much. Yes, thank you.
Bye-bye.
Bye bye.